The ubiquitousness of PFAS has a lot to do with the widespread use of these compounds over the last half century. Most people will know that PFAS were used in nonstick coatings and firefighting foams, but the number of applications for these chemicals was and is truly staggering. When you combine this vast array of potential sources with the recalcitrant nature of these substances and their ability to migrate through natural systems, you begin to understand why PFAS have been detected all over the world, including in obscure locations like the Arctic and even the slopes of Mount Everest.
Welcome to Deals and Developments, a real estate podcast from the Dykema law firm. I'm your host, Grant Gilezan, a partner at Dykema and head of the firm's environmental group. I'm joined today by my guest, Wayne Amber, PhD, who is a principal at the Geosyntec environmental consulting firm. During our discussion today, Wayne and I will be focusing on land transaction environmental due diligence strategies in the growing shadow of PFAS risks. A game-changing development occurred on July 8th when US EPA added 2 PFAS compounds to the list of hazardous substances subject to cleanup requirements under the federal cleanup statute known as CERCLA or Superfund. This was the first expansion of that list since CERCLA was enacted over 40 years ago, which, due to the ubiquitous nature and low action level thresholds of PFAS, has the effect of sweeping in the vast majority of land in the United States as being at risk for containing concentrations of PFAS in excess of cleanup criteria. Given the enormity of these PFAS risks, investors should place emphasis on performing adapted environmental due diligence to evaluate a potential real estate transaction. As a starting point, Wayne, it would be helpful if you could please briefly describe what is meant by PFAS, the so-called forever chemicals.
Sure. Thanks, Grant. The quick version is that PFAS is a family of over 15,000 man-made compounds, all of which are held together with extremely strong carbon-fluorine bonds, which make them very difficult to break down in the natural environment. Of course, this robustness is also what makes these chemicals so incredibly useful for a wide range of industrial, commercial, and household applications, where properties like longevity and thermal resistance are highly desired. So it's fair to say that the forever nature of these newly designated hazardous substances is a problem of our own making.
Indeed. Despite many decades of use, PFAS has only recently reached an active level of public awareness and concern, placing it quickly in the same ranks as asbestos, lead, dioxin, and mercury, because it is both pervasive and persistent over a long period of time in the environment. The US EPA has a growing list of health risks associated with PFAS, including cancer, cardiovascular impairments, immune system impacts, reproductive effects, and developmental delays in children, among others. Wayne, could you please overview how PFAS has become so ubiquitous in the environment and all of us?
Of course. So the ubiquitousness of PFAS has a lot to do with the widespread use of these compounds over the last half century. Most people will know that PFAS were used in nonstick coatings and firefighting foams, but the number of applications for these chemicals was and is truly staggering. This includes many everyday products such as water-resistant fabrics, personal care products, food packaging, cleaning products, paints, and many, many more. Not to mention the wealth of industries that made use of PFAS and often in bulk quantities. Then, when you combine this vast array of potential sources with the recalcitrant nature of these substances and their ability to migrate through natural systems, you begin to understand why PFAS have been detected all over the world, including in obscure locations like the Arctic and even the slopes of Mount Everest.
These incredible human exposure concerns are now driving the rapid creation of human protection standards. On the federal level, US EPA developed a PFAS strategic roadmap, which laid out a planned approach to addressing the toxic and persistent chemicals and safeguarding communities from their reach. In implementing that roadmap, US EPA and several states have issued drinking water, soil, and groundwater surface water interface standards for some PFAS. Wayne, could you please describe which PFAS are being prioritized for regulation and some examples of the low levels being set compared to sampling detection limits?
Sure. And just to reiterate, as I mentioned earlier, there are currently over 15,000 known PFAS compounds. And this number has grown from about 5,000 compounds as recently as 2017. So it is an ever-evolving science, and regulators are faced with the daunting task of translating a loosely understood set of compounds into guidance for the protection of human health. Their primary focus has been on two of the most commonly used PFAS, those being PFOS and PFOA. And the EPA recently published MCLs for these substances at 4 nanograms per liter, which is also equivalent to 4 parts per trillion. And for perspective on those numbers, if you've been following the Olympics recently, 1 part per trillion is equivalent to a single drop of water in 20 Olympic-sized swimming pools. This is very nearly equivalent to the limits that labs are able to achieve for detecting these compounds, which further complicates our ability to accurately characterize risks from PFAS when we find it in the environment.
Turning to our focus today, the objectives for property due diligence under CERCLA all appropriate inquiry requirements and state law equivalents are threefold. First, to help prospective property owners and operators understand the value, constructability, and usability of the property. Second, to give those parties an opportunity to shield themselves from cleanup liabilities for pre-existing contamination on that property. And third, to understand due care requirements going forward to protect all persons accessing the property from the residual contamination that may be present. Wayne, it would be helpful if you could describe the fundamental reconnaissance steps involved in performing environmental due diligence for determining whether a property is subject to contamination requirements.
Absolutely. The steps involved are defined by ASTM, who provides very prescriptive guidance for the performance of environmental site assessments in support of due diligence. It's a stepwise process which seeks to identify evidence of chemical release to the environment. The first phase consists primarily of a historical records review, which is then followed by a phase 2 subsurface investigation to collect actual site data to confirm a release. The amount of sampling data required during the due diligence process tends to be relatively limited, with the objective here being simply to determine whether exceedances of applicable state regulatory criteria exist for the contaminants of concern at your site. This is in contrast to other state and federal cleanup programs where liable parties are required to fully delineate the nature and extent of impacts and evaluate and address human health exposure risk.
US EPA's designation of PFOS and PFOA, the two prioritized PFAS compounds, as hazardous substances under CERCLA, means that as of July 8th, both chemicals must be evaluated as part of the Phase 1 environmental site assessment Wayne mentioned. Additional environmental investigation may be recommended by environmental professionals at properties like Wayne, where there has been manufacturing of PFOS or PFOA, as well as properties where operations may have released PFOS or PFOA, such as carpet and textile production, metal finishing, industrial manufacturing, and areas where firefighting foams may have been utilized, among many others. At this early point, there are more questions than answers when it comes to the specific implications of the presence of PFAS beyond any other chemicals, to property transactions concerning when to sample for PFAS given its ubiquitous nature, the need to distinguish between PFAS releases and generalized background concentrations of PFAS, and how to best address lender requirements in light of PFAS presence. Wayne, it would be helpful again if you could describe for us how traditional environmental site assessments are now being augmented to properly address these PFAS issues.
Sure, thanks, Grant. The introduction of PFAS into the due diligence process is quite the game changer. Where before sampling strategies were generally limited in nature and could be completed using relatively simple, well-established methods, the addition of PFAS requires more intensive planning and quality control measures. Some examples of this include consideration of the types of clothing worn by sampling staff, what type of water is brought on site for decontamination of sampling equipment, as well as many other cross-contamination risks that all need to be taken into account and complicate the process.
Yeah, I appreciate how this indeed has really changed the landscape of an otherwise very established due diligence process to now take account of these new compounds. In that spirit, owners and operators of property contaminated by PFOA and PFOS will become subject to the strict, retroactive, and joint and several liability scheme under CERCLA, even if they did not conduct the activities generating the contamination and may be responsible for the costs or performance of investigation and cleanup, unless they can establish a statutory defense to liability by performing complete and thorough due diligence. US EPA has issued guidance affirming its intent to exercise enforcement discretion to focus on holding responsible entities who significantly contributed to the release of PFAS into the environment, including parties that manufactured PFAS or used PFAS in the manufacturing process, federal facilities, and in other industrial parties. Although US EPA does not intend to bring enforcement against what they refer to as minor, potentially responsible parties, they nonetheless have liability, or those parties nonetheless have liability under CERCLA for the costs of contamination. Therefore, it is important to conduct the appropriate due diligence to determine whether a property is potentially contaminated with PFOA and PFOS before acquiring the property. So a new property owner or operator can achieve eligibility for the bona fide prospective purchaser defense under CERCLA. Wayne, what due diligence information is needed to confidently establish such a defense to broad form status liability for PFAS?
Yeah, so the prospective purchaser protection requires samples to be collected from areas where, again, evidence of release was identified during the phase 1 and phase 2 processes. A prospective purchaser receives liability protection for individual contaminants with concentrations that are exceeding applicable state regulatory criteria. Given what we know about the widespread presence of PFAS in the environment, as well as the low regulatory limits, the odds of identifying PFAS at properties tends to be higher than for other contaminants that we routinely deal with.
All right. Well, with that daunting perspective in mind, we'll close in this manner. Although US EPA in its rulemaking downplays the potential impact of the inclusion of PFOS and PFOA as hazardous substances under CERCLA, there is indeed significant uncertainty for persons acquiring property that may have PFOA and PFOS contamination. Contributing to this uncertainty is the current lack of cleanup standards for PFOA and PFOS that can be used to satisfy the legal obligation to remediate the property, as the current regulatory landscape is a patchwork of state standards, health advisories, and federal maximum contaminant levels for some PFAS, which are in many cases setting limits at the parts per trillion level, making both investigation and remediation extremely difficult. Moreover, the science behind remediating and treating PFAS in soil and groundwater, as well as understanding PFAS exposures and pathways, continues to evolve and develop at a dynamic pace. Wayne and I hope we have shed some light on these expanded challenges to property due diligence and how you can best navigate the significantly increased risks involved in a strategic manner. We'd welcome you to reach us with any questions you may have, and we would be happy to help you address any particular issues you may be facing. That's it for us today. Thanks so much for joining us. For more episodes, you can find us at dykemapodcast.com, youtube.com/dykemalaw, or by searching Deals and Developments wherever you get your podcasts. Again, my name is Grant Gilezan, and we look forward to seeing you next time on Deals and Developments.